My name is Steve Yale-Loehr, and I teach immigration law at Cornell Law School. I feel particularly honored to moderate this panel for two reasons. First, I got Juan into this mess. He was a law student here, and he was looking for a part-time job. At the time, I was working with Maury Roberts, the former chairman of the Board of Immigration Appeals, at Interpreter Releases, and we were looking for a law student to help us out on interpreter releases. And Juan applied for the job. He was clearly the best qualified. Maybe he would have ended up in immigration anyhow, but certainly, Wendy says no. But he started at Interpreter Releases. We loved working with him. I remember walking into Maury's office with him and talking about old cases that Maury had decided at the Board of Immigration Appeals. We worked together for many years, and then I moved up to Ithaca to teach at Cornell, and Juan took over as editor of Interpreter Releases before he went into the government. So I knew Juan for 30-some years because of that. Second, immigration court reform and judicial review were topics that were near and dear to Juan's heart. And so I'm particularly glad that we have such a distinguished panel to discuss some of them and see how we can move his ideas forward and try to make some progress in reforming both immigration courts and judicial review. So my panelists are very esteemed and very able to talk about this. On my immediate left is Jill Family, who's the Commonwealth Professor of Law and Government, Director of the Law and Government Institute at Widener University, Commonwealth Law School. To her left is Karen Grisez, who's Public Service Counsel at Fried Frank here in Washington, D.C. Her particular attributes for this panel was that she chaired the ABA Commission on Immigration in 2010, which had several important recommendations for reforming our immigration court system, and she'll be talking about those. And when the Congress held hearings about those recommendations, she testified, and then Juan was the government attorney at those hearings there. Then we've got Lucas Guttentag, who now is professor of the practice at both Stanford and at Yale, because you can't just do one thing. He has to do many things very well. Before that, he was the head of the Immigrants' Rights Project at the ACLU, and among other things, he argued St. Cyr, INS versus St. Cyr before the Supreme Court, and preserved judicial review against the court stripping provisions of the 1996 law. And finally, but certainly not least, we've got Andy Schoenhalt, who's professor of practice and the director of the Human Rights Institute at Georgetown Law School, who's also written a lot in this area, including a very good book called Refugee Roulette. So let's start with the basics, and then we'll get into immigration reform itself. So Jill, why do agencies have administrative tribunals?
Thanks, Steve. I just want to say thank you to the organizers for allowing me to be a part of this panel. As Steve mentioned, one of the things I do at Widener is I run the Law and Government Institute, which is a way that students can concentrate. Oh, now it is. Sorry. Oh, that's really loud. As they can concentrate their legal studies in government law and earn a certificate in government law when they graduate. And I knew Juan. I didn't know him super well, but he is always sort of in the back of my mind when I'm talking to students and thinking about the kind of public servants I would like them to be. So hopefully we're training some students who can at least be half as good as Juan was. So your question, though, was not that. Your question was, why do agencies have administrative tribunals? So I guess to even take a step back, administrative agencies, if you think about it, they're governed by the Constitution, obviously, and statutes. And those statutes include the Administrative Procedure Act, which is the statute that sort of generally governs administrative agencies. But they also can be governed by other statutes. So Congress by statute may override what the Administrative Procedure Act says that an agency should do in a certain situation. And so some agencies end up working under sort of a hybrid system where they do some things under the Administrative Procedure Act, some things under what we call the organic statute, which is the statute that Congress created for that particular agency. So, for example, in immigration law, judicial review is not governed by the APA, but instead there's a statute in the Immigration and Nationality Act that specifically governs judicial review. So, that being said, it's always helpful to look at what the Administrative Procedure Act says, since that's sort of the starting point, and that's those are the general rules that apply to agencies unless something tells them to do something different. So the Administrative Procedure Act divides the universe of agency activity into two things, rulemaking and adjudication. Our focus today is on adjudication, but it is interesting to note that generally an agency is free to choose whether to proceed by rulemaking or adjudication, unless, of course, some statute tells them they have to pick one or the other. So if we're just looking at agency action in the form of adjudication, and then our next question is, well, what kind of procedures or what kind of restrictions are there on the procedures that agencies can use in adjudication? Well, there's always the Constitution out there, right? There's the Due Process Clause. And then the Administrative Procedure Act divides the world of adjudication into what it calls formal and informal adjudication. And whether an agency uses formal or informal adjudication, again, is mostly up to the agency unless the organic statute requires the agency to use formal adjudication. But the Supreme Court has ruled that Congress has to use very specific language to trigger formal adjudication. So there's not as much formal adjudication as you would think, and one of the reasons why is because Congress has to use sort of like a catchphrase, a key phrase, to require agencies to use formal adjudication. So the Administrative Procedure Act has a lot to say about formal adjudication. In formal adjudication, the agency has to use an administrative law judge to conduct the proceeding. And administrative law judges have a lot of protections. They can be removed only for cause, and that cause, whether a cause exists, is determined by an independent agency, the Merit Systems Protection Board. Their salary is determined by length of service. They cannot receive bonuses. They are exempt from performance appraisals. Their hiring used to be overseen by an independent agency, that's OPM, but that's evolving and changing under the Trump administration. The APA has very little to say about informal adjudication, and informal adjudication is immigration removal adjudication. So informal adjudication uses what we call administrative judges, not administrative law judges, just administrative judges. And as I said, the APA itself sort of requires very little, or doesn't really have a lot to say about what informal adjudication should look like. Now, there's still the Constitution out there, right? So that provides due process protection. The organic statute can say a lot about how an agency should act in a particular informal adjudication. And the agency itself can set its own regulations telling itself essentially how it should act in a formal adjudication. Now, non-ALJ hearings, so those are administrative law hearings that are overseen by an administrative judge, not an administrative law judge. So these are informal hearings, actually greatly outnumber formal adjudication. So if you look at the whole landscape of administrative law, not just focusing on immigration law, a recent study found that there are almost 11,000 administrative judges and almost 2,000 administrative law judges. So there are a lot more administrative judges overall in administrative law than administrative law judges. The vast majority of administrative law judges work for the Social Security Administration. The vast majority of administrative judges are patent examiners. Who knew? There's over 7,000 of those. Immigration judges and board members, of course, are not administrative law judges. As I said, they're administrative judges. We're looking at around 320 something of those immigration judges plus board members. IRS actually beats out immigration law. There's 714 administrative judges,
and the Veterans Administration has 630 administrative judges. So for administrative judges, it's really hard to generalize about pay, titles, whether or not they get performance reviews, because the APA doesn't really provide a strong central guiding standard like it does with administrative law judges. So hopefully that gives you sort of a sense of a broader landscape of administrative adjudication.
So give us some examples of administrative review in other agency settings. So we know how it works here in immigration land. We all know that, but give us a broader perspective.
Right, so the PowerPoint slide that's up now is, the immigration removal appeals, just to, sort of see you how I envision it in my fancy PowerPoint presentation style. But if you can go to the next one. Okay, so here I'm mostly going to talk about veterans appeals, but I did also want to put up some information about Social Security disability appeals. So this is what the Social Security disability appeal system looks like. So everything that's in blue, those first 4 bars, that's administrative adjudication. So you can see there's, the first you apply for the claim. If it's denied, then it can be reconsidered. Then you get a hearing before an administrative law judge. So that's formal adjudication under the APA. But then there is this thing called the Appeals Council, which my understanding is those are not administrative law judges. So that's sort of a bizarre scenario where you have non-administrative law judges reviewing the decisions of administrative law judges. And then, of course, you can ultimately, your first shot at Article 3 review is in the U.S. District Court. And so, in thinking about, what to talk to you about and what to compare, it's sort of hard to find the perfect comparison because I picked Social Security and Veterans Affairs because those are the 2 other big sort of mass volume, high volume mass adjudication kind of systems. But, Social Security, but then I was thinking, applying for Social Security or applying for veterans benefits, is that more like what USCIS does just in terms of the work that they're actually doing? So it's hard to find a perfect comparison. But let me talk to you about veterans benefits appeals. I'll give you a little bit more detail about this. Again, blue is administrative adjudication. Here we have an Article 1 court in the form of the Court of Appeals of Veterans Claims, and then the first shot at Article 3 review is the U.S. Court of Appeals for the Federal Circuit. So I'll just start at the bottom where it says claim denied. So your first shot at adjudication is completed by someone called a rating specialist, which is a single lay adjudicator. You can ask for reconsideration, and that goes before what's called a decision review officer, and that person is a senior regional office adjudicator. From there, you can appeal to the Board of Veterans Appeals, and that is staffed by 100 or so veterans law judges. Now, they are not administrative law judges. They're administrative judges, just like immigration judges are. But it's interesting because when you start to look at how even the Board of Veterans Appeals is structured, you can see how the possibilities are sort of almost endless in terms of the variety and ways that you can structure administrative adjudication. So the veterans law judges are appointed by the Secretary of the VA with the President's approval based on the chairman's recommendation. So there's a chairman of the Board of Veterans Appeals who's appointed by the President with Senate confirmation, serves a 6-year term. There are statutory limits on the chairperson's removal, and that person reports to the Secretary of the VA. The veterans law judges oversee a process that's meant to be non-adversarial. So I thought this was really interesting. No attorney appears for the government to oppose the granting of benefits before the Board of Veterans Appeals, which is certainly very different than in immigration court. Now, if you're unhappy with the decision of the Board of Veterans Appeals, you can appeal to the Court of Appeals of Veterans Claims. Now, it's interesting because until 1989, there was actually no judicial review of veterans benefits decisions, none. So whatever the agency decided was the final straw. But Congress created the Court of Appeals of Veterans Claims in 1989, and it consists of it's an Article I court. It consists of 9 judges. They are appointed by the president and confirmed by the Senate. They serve 15-year terms. They sit either in 3-member panels, single member, or en banc. Apparently, they have a really robust mediation program. And they can review questions of fact under a clearly erroneous standard. They review questions of law de novo, and they review discretionary actions under the arbitrary and capricious standard. Now, if you're unhappy with the decision of the Court of Appeals of Veterans Claims, there is a very limited scope of review in the U.S. Court of Appeals for the Federal Circuit. So the appeal is of right. You don't have to ask for cert or anything like that. But the review is limited to pure questions of law. There's no review of factual determinations or even of applications of facts to law. So it's there's sort of 2 layers of judicial review in the sense that you've got an Article I court and then the Article III court, but the scope of review in the Article III court is pretty limited. And the last thing I want to mention is I've given you these 2 examples, but I really want to emphasize that no administrative adjudication system is perfect, right? People complain bitterly about veterans benefits appeals and Social Security appeals. Just to give you some data about the VA, sad, but we should feel like we're not completely alone out there. There's a backlog of 450,000 appeals pending before the VA. I mean, we're winning that great competition, but they've got a huge backlog. They're experimenting with, they have this program called RAMP that they're experimenting with where you can choose one of 3 lanes for your appeal. It takes 6 years to get to a Board of Veteran Appeals decision. So that's not even all the way up the chain. And there's all sorts of complaints about how the Court of Appeals of Veterans Claims, that they're not harsh enough with the Board of Veterans Appeals, that they're sort of too quick to remand cases instead of reversing them. So, that's not to say that there aren't things from these systems that there are things from these systems that we can learn, but just keep in mind that no one has developed an administrative adjudication system that everyone is thrilled with.
But I'm sure we'll do that in the next 30 minutes.
Yes.
And while we're doing that, we'll also talk about judicial review and cure any problems there. So Lucas, why don't you tell us about I missed that day in law school where they talked about judicial review. So can you tell us what judicial review is for generally and then specifically in the immigration context?
And I have to confess, when I was in law school, I never took administrative law, to my great regret.
Lucas.
That was a mistake. And that's what I tell every law student. Take it. So yes, let me talk about that. But I do want to start just by saying how honored I am, like everyone else who's a participant here and present, to be on a program honoring Juan Osuna. I got to know Juan almost when I started in the field more than 30 years ago, when, as you said, he was a young editor, interpreter releases, and I was starting out the program, the ACLU Immigrants' Rights Project, and I was sending the results and cases we were litigating to interpreter releases really for selfish reasons, which is I wanted to promote what the ACLU was doing. And it's hard to imagine, what interpreter releases was then for those of you who've entered the field more recently, because it was the source for immigration for every single immigration practitioner, immigration judge, everyone who had an interest in the field, through Maury Roberts, through Steve, and through Juan. It was the single source. There was no social media. There was no email. Everybody read interpreter releases, and everybody had enormous respect for all of you who edited and wrote that every single week. And then when Juan became a prominent public servant, I just developed enormous respect for him, because he was first a participant at the BIA and then a leader in the whole administrative adjudicatory process. And that was what we were oftentimes suing. And Juan always wanted to improve the quality and the fairness of the immigration administrative process. And at the same time, he always recognized that the administrative process could never be a substitute for federal court review. And that was something that he valued. He didn't resist it. He encouraged federal court review. So he was just, to me, a beacon of what it means to be a public servant. And I saw the same thing when I went into the Obama administration for 2 years, when I saw Juan in meetings with government officials, high government officials in the administration, and he was under enormous pressure to change the way the immigration courts work, to change what EOIR was doing. And he recognized that he wasn't in charge and that there were obligations that he had, but he never, ever wavered in defending the quality and the independence of the immigration court process against incredible pressure. And so, you know, what he did, I think, for all of us, and for, as Ali and as Don said, for immigrants, non-citizens in this country, just can't be overestimated. And he also gave me the quintessential pithy advice when I first went into the government, but I'll save that for when there's time for personal reflections later in the afternoon. So let me turn to what you actually asked me about. But I do just feel like it's so important, and it's such a privilege to recognize Juan. So judicial review, which is to say access to an Article III court, which is in Jill's diagram here, the Court of Appeals or the Federal District Court, ultimately the Supreme Court. I'm struck by the emblem that is used there. I don't know what that is. It looks like a lightning bolt, which doesn't look that. I would rather see, like, you know, the Constitution or a safety net or a gateway or somebody, maybe if you're into weaponry, you know, someone with a sword who's pardon me?
Or a shield.
Or a shield, right. But judicial review basically is, I think, designed, you know, there's two principles. One is it protects the constitutional rights of individuals against government violation. And that's a core separation of powers principle, that the executive branch or the legislative branch doesn't get to act alone, that the ultimate check is by an Article III court, and that's principle one. The second thing, and I think a lot of what Jill was talking about, is that the courts also provide a really important and critical check on agency actions. As a general matter, there's a presumption of judicial review of agency action, and that agencies can't act without the supervision of an Article III court. Now, it's true, and it gets complicated, because some matters can get committed to agency discretion. And so then there becomes a question about what's the line between what is permissibly given to agencies to decide in their discretion and what can an Article III court oversee. And as a general matter, clearly agencies can't violate the Constitution. Generally, they have to comply with the law, but then they can't act arbitrarily and capriciously. But then where are the lines of what's a discretionary decision and what is an agency allowed to decide as a matter of discretion? But it is a core principle of administrative law that as a general matter, agencies are subject to review by an Article III court.
And what about the immigration context? Can
So
you tell us about some of the restrictions that Congress has tried to impose?
Right, as you're well aware, right, we talked about what these questions were going to be, and so Steve did a fabulous job of organizing this into a kind of structured conversation. And immigration is interesting and different, and there's a lot of analogies to every administrative process, and the Veterans Appeals and Veterans Benefits is one of them. The Social Security Administration is another. There's an enormous number, obviously, of agencies and a lot of review in many circumstances of agencies' decisions. Immigration is different. And it's different in a really critical respect because the basis for judicial review of immigration decisions is rooted in the suspension clause, the guarantee of habeas corpus in the Constitution. That because an immigrant has to be taken into custody and to be removed against his or her will, that triggers, as the courts have repeatedly recognized, the great writ of habeas corpus that's derived from the Magna Carta, that's protected by the Constitution. And so the foundation for judicial review in immigration proceedings is not just based on these general principles that agencies are subject to oversight by an Article III court, but by the specific protection that the writ of habeas corpus protects an individual, any individual, including non-citizens, against unlawful detention, and that means removal in violation of the law or the Constitution. And that principle, which the court has recognized again and again, has been under enormous attack, not just in this administration, but much more broadly since 1996. And when the 1996 laws were enacted, there was a fundamental challenge to the ability of federal courts to review the actions of the Immigration Service, INS then, DHS now, both with regard to broad policies and with regard to individual removal orders. So we see that playing out again and again and again when there's restrictions on individuals seeking judicial review, and then in particular when there's litigation overseeing policies and practices. And there's this whole complex web of barriers, restrictions, prohibitions, impediments to courts. And we see it now, to name just a few, playing out with regard to the class action challenge to whether children should have the right to appointed counsel in immigration proceedings. Is it permissible to put a child through deportation removal proceedings without a lawyer at all? And the Ninth Circuit ruled that that challenge can't be brought in a class action. It has to be brought only through a particular individual, which is a practical matter, makes it much more difficult. We see it in relation to the current challenge to the Attorney General's decision in matter of AB, which is being litigated in the expedited removal context here in DC, which again imposes all sorts of restraints. We see it with regard to challenges when the Trump administration wanted to deport Syrian Christians without giving them an opportunity to apply for protection against removal based on the changed circumstances in Syria, impediments to judicial review. So in every one of those circumstances, it's happening now again with the challenge to the president's latest executive order and the new regulation on prohibiting access to the asylum system for those who cross the southern border without permission. So it's a transcendent issue in terms of meaningful oversight over the immigration system, even though it's strongly rooted in a separate and specific protection of the Constitution.
So Andy, now that we know a little bit about administrative adjudications generally and judicial review generally, it's drilled down into the immigration court system. And why don't you give us a little bit of overview on how that works or doesn't work?
Thanks, Steve. First, let me thank Steve because he's done a tremendous job organizing this panel. A lot of work went into this, so thank you so much. Thanks to Don for organizing this day. I think we all felt how moving both Don and Ali's remarks were this morning, and we're all honored to be here to pay tribute to Juan. I just want to say one more thing about Juan before I get into to answer your question. So I think of Juan as an educator. And I think it's because he educated all of us. Now, he did that in specific ways that we think of as education, right? I brought him to Georgetown to speak to my students every year for more than a decade. I got him to teach at Georgetown after he was teaching at George Mason. He is an educator in that sense. But he's also an educator. If you listen to the way people were describing him today, he was educating his colleagues all the time. And one of the most remarkable times I remember him educating, he had to educate Circuit Court of Appeal judges. In 2000, I think this is around 2008, we held a seminar for judges, these judges, and Juan came to help them at the beginning learn yes, this is what an immigration judge decision reads like, and here's why. And then he went around the country to educate Circuit Court of Appeals judges when they were overwhelmed with immigration court cases. He was an educator, and we were, just lucky that he spent all that time with all of us educating us. Now, to the question. So, not surprisingly, the immigration court system is complex, right? Because 3 agencies are involved. It's not just the Justice Department's Executive Office for Immigration Review, right? You've got the 3 agencies at DHS who start the process. And I want to focus for a moment on that process. From the very beginning, this is very different from the criminal justice system, where prosecutors, whether they're U.S. attorneys or district attorneys, lawyers, initiate cases. They set priorities. They direct law enforcement what to do. That is not the immigration court removal system. The removal system, the court's role is to determine, of course, whether or not a non-citizen can remain legally in the United States or has no rights to stay and therefore orders their removal. But the agencies, the 3 DHS agencies that initiate this process, well, ICE, until 2014, actually initiated the majority of cases through the notices to appear. And those involved largely cases of people who are already living in the United States. We call them in the interior, right, to distinguish it from the border. They were already in the United States. Some were lawful permanent residents who were placed into removal proceedings. Some were unauthorized. And all the way as late as 2011, for example, 60% of the notices to appear came from ICE. Well, we're in another world today. The latest data we really have to talk about this was put out by a previous administration, 2016 data. Only 16% of notices to appear are now issued by ICE. CBP issues more than 50%, and USCIS issues more than 30%. And we know why this is the case, right? This is the response of the government to the arrival of Northern Triangle, particularly families, right? And also unaccompanied children. This is the response, and that's why we have this huge shift. So those are in the formal immigration court removal system, where people are entitled, at least theoretically, to a full hearing, right? If they're lucky enough to have representation and quality representation, which really requires a lot of luck. But then there's the other removal system, Steve, and that's the summary removal systems that Congress created, particularly as you've already heard, was created in 1996, right? And that created expedited removal and made reinstatement of removal, of course, an also important aspect of the removal system. Expedited removal, by the way, results in a final order of removal. It's not executed by an immigration judge. It's executed by a CBP official, okay? If you look at the statistics at this point, summary removals were already the majority in 2011, though interior removals by ICE were still significant. In 2016, we're in another world already. 340,000 formal removals in that year, in that fiscal year. Nearly 85% came from expedited or reinstatement of prior removal orders. Only 15% came from interior removals. Why did that change? It's a combination of the funding that Congress gave to the border CBP, increased border removals based on the strategies that were being developed by CBP, as well as the use of prosecutorial discretion, which we'll talk about more in a little bit, by ICE. I'll stop there for a moment.
Karen, why don't you take us over and talk about some of the problems with the immigration court system?
I'll do the best I can with that.
Short period of time.
Let me start out, though, I'm going to echo Thanks. The thanks of everyone else to Don for inviting me to participate in this program and tribute, and to Steve for getting us organized. I also have some personal things to share about Juan later if we have time to do that, but it's hard and meaningful for me to be able to be here to do this morning. And actually last night when I was reviewing some of my planned remarks, it actually went through my head. It's embarrassing, but I'm like, oh, I have to ask Juan if it's okay to say that, right? And then I had to remind myself, right, of what the context is and why we're coming and why I can't do that. But it's actually interesting to talk about these topics and Juan all at the same time, because Juan was involved in the very first immigration case I ever did. In my law firm pro bono management context, we had taken on a case. Unlike Lucas, I did study admin law in law school. I didn't study immigration law. So I didn't know anything about immigration law at the beginning. And we took on a case that was involving something about mixed motive, an Elias Zacharias issue very early in the time. And we were asked to do an amicus brief to the Fourth Circuit on behalf of the Washington Lawyers Committee on this mixed motive issue. And my job was to find a summer associate who could do that. So I got a Hill staffer who had worked with Howard Berman, who actually knew something about immigration law, to write that brief. And then lo and behold, that fall, the Fourth Circuit granted oral argument in the case. Summer associate long gone, nobody in my firm there to do that. So the question was, hey, Karen, how would you like to argue this in the Fourth Circuit? And that's when I first met Juan. He was at Interpreter Releases, and he agreed to come in and do a moot to help me get ready for the things that might come up in that argument. What actually did come up is the first question out of the panel was, so why should we help your guy who stole a place in line, butted, took a visa number away from people who were waiting overseas the right way? So I actually had to abandon my whole argument and talk to the panel about why the asylum system is different from the visa number system. And I barely knew it myself. So it was a good thing that I knew Juan and could, call back on him over the years. What's wrong with the immigration system? Well, a whole lot. One of the things I felt bad about saying is it's not functioning very well at all, but then I realized that's not actually a secret or a very controversial proposition. I'll give you some data. I worked, as you heard, closely with the ABA on the report that we did with the Arnold and Porter law firm in 2010 about reforming the immigration adjudication system. And I'll give you a couple of data points. At the end of 2010, there was a 267,000 case backlog. August 31st of this year, 764,000 cases. Not enough immigration judges in the system. In 2010, we recommend moving from 231 to 331 judges. Now there are actually 395 on board, and the backlogs have grown to that extent. Immigration judge caseloads up as well. Backlogs, everybody know, people are now getting dates in 2022, and those aren't even in many cases real dates, those are holding dates. So the backlog situation is terrible. Funding is an issue. You heard a bit earlier that funding for enforcement has increased and increased and increased, but funding for the immigration courts that actually have to deal with processing those cases has not kept pace, and that's something that Juan tried to work on through the budgeting process and also at the interagency level when he was there, but that has not worked. Here we have more border enforcement, less rather than more prosecutorial discretion at the agency levels. Everybody put in proceedings, everybody being forced to go through proceedings all the way to an order. And then the few things that have happened even more recently, the end of administrative closure with more cases than likely to be staying in the system or getting recalendared, end of TPS coming, redesignation of UACs, forcing more and more cases out of the affirmative asylum process and into the immigration courts. gives me a picture in my mind that's like Lucy on the candy line, you know, more and more inputs going into the system and not the resources being put on the line to handle them. So what do you see? Some of the cases are getting completed properly and put in the boxes and wrapped up with a nice ribbon, but not very many. More of them fall on the floor, get eaten by the system, get tossed over somebody's back shoulder, and that's the image of the way I have that. In fact, Appleseed Network wrote a report in 2009 calling for a lot of adjudicatory reforms, and it was called Assembly Line Injustice, and that's the image that I have, that the move is pushing more and more to an assembly line where the idea is to get cases through the system without focus on the outcome, what the product looks like at the end and whether justice gets done, which is certainly at odds with the legacy that Juan tried to create. A couple of other things I'll say on problems in the immigration court system, access to counsel still a problem. No right to counsel at government expense. Juan worked very hard on trying to do something about that at the vulnerable populations level for the mentally ill or mentally disabled in implementing the Franco Gonzalez decision, going beyond what was required to happen in the Ninth Circuit and creating a program that served people in that category nationwide. And of course, on the children issue, creating all these kind of programs to serve children and provide ways in which children could not only get screened but get representation. And those certainly I'd say are going in the wrong direction today with the defunding of several of those things, the wrong way rather than the right way. So other problems in the immigration court system, perception of unfairness in that the new appointees are more and more former government, former ICE, former trial attorneys, former enforcement people at a much higher proportion even than before, and that the selection process and the clearance issues are slanted in a way that makes it easier for those folks to get through faster and therefore make up an increasingly large complement of the immigration judge bench. And then the one we can't overlook, the lack of independence, where the structural problem of placement of the judges within Department of Justice and the direct control by the Attorney General, the way the performance reviews are structured, and now in recent times, the imposition of processing quotas, mandatory reversal rates that have to be monitored, and interestingly and disturbingly recently, the reassignment of cases away from particular IJs to other sent in and assigned IJs when there have been issues of particular concern coming up. So
other than that, everything is fine.
Yeah, yeah, Mrs. Lincoln, everything's going pretty well other than those few things. So we can talk more about recommendations, but that's a good overview, I think, of the problems.
So in terms of recommendations, Andy, Juan, knew about all these problems. He had some well thought out ideas about reforming our immigration court system and immigration enforcement generally. Why don't you summarize those for us?
Sure. So let's start with the goals here that Juan had in mind. He was trying to balance two critical values in a very large caseload system. One is efficiency, and the other is justice. So I'm going to get to read to you a telling line by Juan when he testified in 2011 before the Senate Judiciary Committee. And this is how he talked about that balancing. While we take seriously our responsibility to decide cases in an expeditious manner, the utmost priority for every type of case is ensuring that every fact is considered and every application of law is correct. That's Juan's way of balancing, right? Now, let's get down to how he actually envisioned this happening. The first important concept that Juan understood better than most in the government, frankly, was to look at this holistically. He was looking at the life cycle before life cycle was a word that the government started to use. Maybe it's only in the Office of Immigration Statistics, I don't know, but it's a word now. He was looking at holistically because he recognized that resources would always be limited and that the backlog of cases kept increasing. Something had to give, something had to change, because he knew he didn't have enough resources to deal with this, never would, at the immigration courts. So he recognized priorities had to be set to govern it from the very beginning. And he was one of the champions of prosecutorial discretion. Now imagine a judge arguing for prosecutorial discretion to law enforcement, right? That's what was happening. That's what Juan was doing. He was a judge doing this, right? Well, you know, he was the head of the judges at that point, of all the judges, both the appellate and the immigration court judges. So he, from the outset, he really tried to articulate that, and he was successful to some degree, right? We finally did, for some period of time, begin to get initial prosecutorial discretion being used by law enforcement officials. His idea was that every notice to appear should be issued by the prosecuting office, right? Nothing should happen until they decide this is a case where they want to follow from the beginning to the end, use all the resources of the government to make that happen. And what he knew would happen if that was the case, would that the numbers, the caseload would come down because they'd have to prioritize based on resources. So the vision was critical in what he championed. Okay, how did he then technically try to make some of this happen? Hiring new judges was a big issue, right? He advanced that early on in the Obama administration, and I think if it wasn't for the recession, he would have made a lot more headway. When the budget, when DOJ and the White House told him, after the first year that it was going to be hard to do that, that slowed down. But he in the his reforms all the way through were to focus on hiring, and not just hiring more, but it was also to hire quality. Yes. And that really was an important part of this. One of the problems perhaps we'll get to is to ensure that the judges are the highest quality, the best lawyers in our society who take that on. Second, he realized the importance of training. He wanted to develop more quality training. That required resources too. That just doesn't happen. EOIR was one of the most neglected institutions in the immigration system, and they didn't have the funds to do that well. He tried to promote that. He also tried to shift the sort of heavier headquarters management system to the field, because he understood that's where the needs are greatest, and there's got to be some way to redesign the management system to get there. And then I would say finally, he championed prioritizing the detained caseload as much as possible and recognized the failures when the Obama administration prioritized the border caseload instead. And he was very direct about all of that. So I would say in sum, those are the particular ways, but it was his efforts to try to achieve this difficult balance between efficiency and justice, and I think we know where he landed on that.
Great. Well, let's jump ahead only because we're running out of time. It seems like there have been two sort of main recommendations to reform our immigration court system. One is to have an independent immigration court outside the DOJ, and another is to have an Article I court. Karen, why don't you start by sort of summarizing those recommendations and the pros and cons of each, and then everybody else can chime in with their own views on how they would see how we should reform our immigration court system.
Right. Well, I'll start with the ABA one just because, as I said, I'm most familiar with that. And in 2010, the ABA's main point was that the immigration court system should get out of DOJ. But at that time, we said it could be either an Article I court or a close but acceptable alternative would be an independent agency outside of DOJ. even before the ABA came out with that report in 2009 was the Appleseed report that I mentioned, and they had already at that time called for the move to an Article I court as the preferred alternative. Then over the years, more and more separate entities have started to move toward the Article I recommendation, and I'd say momentum is really building in that way. The Federal Bar Association, the National Association of Immigration Judges, AILA itself have all come out with recommendations of Article I. And the official ABA policy has not changed. So I can't say that the ABA policy is squarely in favor of Article I, but the updated 2010 report is expected to come out early in 2019, around late January or the 1st of February. And we are, at least in the report, not as official policy, but the Commission on Immigration is going to make a recommendation that the Article I court is the preferred alternative, that the ABA may or, as a whole may or may not later endorse that as policy. The features, I think the biggest one is independence, get, outside of the direct control by the Attorney General. That's control over management, control over process, control over policy, but also control of decision making. And I remember one time, one thing that Juan said was that he could handle hiring judges, hiring courts, building buildings, working on priorities, moving caseloads, but as soon as there was interference with substantive decision-making, that would be the point where he could no longer take it. Now, obviously, he's not been there since some of the things that I described have really increased so dramatically, but I can only say that was kind of a canary in the coal mine comment about where things were headed. So judicial independence, making the immigration judge corps true judges who are not worried about their jobs, not worried about performance evaluations, not denied the ability to give continuances, manage their own docket, decide how much time an individual case should take or when somebody should get more time to look for a lawyer. Those are the main things. I think I don't want to say fight, but the discussion moving forward really is going to be on what are the features. Some of the groups think that the model should be the bankruptcy court model. Other ones think it's closer to the Veterans Court model. And one thing I was reminded of when Jill was talking, because I've done some Veterans Court work as well, especially in earlier years, one thing I really like about the CAVC process is that they have a mandatory settlement conference where a staff attorney from the court has a telephone conference call with both parties. It's like a pre-hearing conference, except it's on the phone, and there's an effort to narrow the issues, and it's mandatory. Everyone has to participate in that, and the appellant puts out their view, the other side responds, and the staff lawyer tries to figure out, can you agree on a remand? Can you narrow some of the issues that have to move forward? That's a really good feature. So the features, what should be the terms, what should be the mechanics of appointment, who should supervise, what should the disciplinary features be, those are the things that I think are up for contention, but I think the momentum is quite squarely moving, right, towards the Article I court.
So Jill, I mean, are Article I courts a panacea, or are there some potential problems that we need to think about?
I think an Article I court will be extremely helpful in terms of the independence issue, and I'm all for it, and I totally agree that immigration judges desperately need more independence. But I also agree with Juan's holistic approach in the sense that I think you can't just think about decisional independence because so say immigration judges have decisional independence. That's great, but they're still going to be applying the immigration law, the substantive immigration law that we have, which is really harsh, complex, doesn't really leave a lot of room for immigration judges to judge, right? I mean, they don't get to look at a case and sort of say, here's what I should think happens. I mean, the result is often just dictated to them. So I think you have to look at adjudication reform as sort of one piece of immigration reform in general in terms of the substantive law. I also think absolutely crucial, you got to think also about when Andy was talking about what I've called the diversions from the immigration court system, expedited removal, stipulated removals, all of those things, because that's really where the meat of the action is. I think you have to think about, we could have this perfect immigration judge court thing, but if only 2 people ever get to go to it every year, what's the point of that? And the last thing I want to mention is, in thinking about an Article 1 court, is I think there's a lot we can learn from the Veterans Court, others examples, by looking at some of the problems that they have, picking out the good things too, but looking at some of the problems that they've had and thinking proactively about them, like how I mentioned that a lot of stakeholders think that the Court of Appeals of Veterans Claims treats the agency with kid gloves. Like, even though they're separate, they still sort of, favor them and favor remands, even though in veterans law, there's a rule like in immigration law that, you're sort of supposed to favor outcomes that are lenient towards the veteran and towards the immigrant.
So, Lucas, what are the main problems with judicial review of immigration court decisions, and what are your recommendations to solve those?
I think that first, what Jill just said is so critically important, that we can have the best administrative adjudication process in the world. If the substantive law doesn't change, there's very little for even the best process to do. So I absolutely agree. We have to have reform in the adjudication process, and we need to improve it. That means a broad spectrum of judges, not picked because of their ideological predispositions. It means that there needs to be real independence, and of course, critically, there needs to be real, full, and meaningful access to an Article 3 court to oversee everything that the agency is doing, not just a small piece of it, not just those cases that go through the immigration court process, that both individual cases and systemically, there needs to be a recognition that the most vulnerable people in our society need the most robust review, not that non-citizens should be subject to more restrictive review. All that said, I think we also have to recognize that the courts themselves are under incredible pressure now. And I don't have that great a confidence about where the federal courts are going. We know what the appointments look like. We can see where that's likely to end. So we need and let me say one other thing, that the need for review, it's not just because of what the policies are currently in the Trump administration. Some of the worst positions with regard to access to the courts and judicial review were taken by the Clinton administration, were taken by the Obama administration. Every administration wants to insulate executive action from Article 3 review and from judicial review. So this is an endemic problem. So the courts need to be robust, and the judges on the courts need to be ones that recognize the importance of protecting non-citizens, both substantively against discrimination and with enforcement of fundamental due process rights. And I think, to kind of maybe end where we began, Juan embraced those values in every respect and would be supporting all of that if he were here to speak about it today.
Last, Andy, you want to add to that?
Yes, thanks. So I just want to remind us what the types of cases that the immigration courts are deciding. Right? These are life-changing cases. Historically, it's been asylum, cancellation of removal, the lives of lawful permanent residents who've been in the United States for a long time, the lives of unauthorized immigrants who've been in the United States for a long time. There's a lot at stake in this. And if you look at the latest data on asylum applications, we're talking 140,000 applications in FY 2017, 160,000 in FY 2018. Why? Because of the Northern Triangle flows and these credible fear interviews, et cetera, the determinations. That's all increased. So we're talking about a system that's going to have more decisions to make with regards to people who are claiming fears. And this is, at the end of the day, you know, the reason why independence really matters, Steve. So let me just say one more word about independence. The first step to try to make the system more independent was taken in 1983 when EOIR was created. The adjudicators back then were part of the Immigration and Naturalization Service. So the first step was 83. It's taken us a long time to get to what the next step is. Whatever the form of independence ultimately is, it's the independence and the significant degree of that that matters. I think we learned that. The reason there was a great push at the ABA was that was after Attorney General Ashcroft essentially removed half of the Board of Immigration Appeals because of politics. And now we're seeing the next stage of that. Independence is what's called for in an American system of law. And at some point, hopefully we'll get there. And I know that Juan believed in that, even though he had to work within ways to make that happen inside the Justice Department.
So last question before we open it up for questions generally from the audience. Do you think we can solve the immigration court and judicial review problems by themselves, or do you think we have to do it as part of comprehensive immigration reform? Karen, you want to start?
Well, I agree with everyone else who said you need substantive law reform because judges and structure can only do so much if you don't have laws that are up to the challenge and that address the current immigration situation in the country. So I think we need CIR. I think we also need structural change, but we also need the other type of reforms that are addressed in the ABA report and otherwise. And I failed to mention the DOJ's own Booz Allen study before, but a lot of the things that were recommended there that haven't happened are also really critical reforms. That was performance reviews should emphasize independence and not quotas or deadlines, better access to counsel, more LOP, not less, more admin closure, not less, and a limit on the use of video conferencing. And those are all things that come up over and over and over in many reports, but it's critical that the DOJ's own commission study recommended those things and then they went the other way. So as the ABA's approach was, look at inputs from the beginning of DHS putting cases into the system, to the courts, to the BIA, maintenance of judicial review, looking at access to counsel, and looking at structure. They're all important, and no one of them individually will produce the kind of change we need. We need all of them to work together to make this a better system.
Lucas, you want to add something?
Well, yeah, I mean, I agree with that because I think we need both and I'll take anything. If we can get some positive reform along any of these lines, that's a huge advance. And I think the one thing that the current administration has done has exposed, both the harshness of the laws and that what an administration can do with the power that exists. And so therefore the law needs to be constrained. And it's demonstrated the critical role of the federal courts in checking the executive branch when it violates the law, when it fails to comply with the Constitution. So we need a reinvigorated, public intellectual campaign and a movement for the rule of law and for humanitarian immigration reform in order to address all of these problems and at least to start down the road of achieving that.
Well, I think that's a good way to end the formal part of our panel. We need more Juan Osunas, basically, and everybody here in this room is contributing toward that effort. We do have a little bit of time, so if you have any questions, come up to the microphones. And if you could introduce yourself, too.
I'll speak loudly. My name is Alice Farmer, and I'm with UNHCR. I'm curious to get from the idea of increased independence what are the steps that need to happen politically, and how realistic do you think they are?
Karen, why don't you start with that? That's an easy question.
Yeah, what needs to happen politically? Wow. Well, I mean, honestly, I think it's started now. I think the momentum has started now, where when Article 1 or even the independent agencies started being discussed years ago, it seemed like pie in the sky, and it seemed like, or to use another metaphor, tilting at windmills, like in an abstract construct, that's something that would be better, but as a practical matter, moving from here to there is something that would never fly. Now, I think as, I don't know, nearly a decade and that conversation has moved forward, the recognition is more that the problems are becoming intractable in the current system, and this is never going to work. So I guess, oh, sorry, I don't see where the lady went.
Alice is sitting
Here.
down again.
So I think now the momentum is shifting and people realize there's a change. Now I think it is the details of what the features should look like, what the structure should look like, and that needs to be talked about. And my own view, speaking for no one, is that all the groups working on this need to come to a consensus around what the basic features are, and have a more or less unified proposal to go to Congress so that everybody that's affected pretty much agrees on the key principles, and then try to build the political will to make it happen. But obviously you have to be able to attract constituencies on both sides, and the trick, I think, is to address what Andy was talking about, the efficiency and justice. There are people who get it and are primarily motivated by one or the other, and I think there needs to be a way to show how cost savings, efficiencies, reductions in backlogs can be helped by some of the structural changes that we're talking about. But a big one that has to be confronted is the access to counsel issue, because records don't get better, cases don't move more quickly, and just outcomes don't happen, and avoiding motions to reopen don't happen if cases don't get addressed for the first time until you're at judicial review or on motion to reopen. So opening the system to counsel at an earlier level, I think, is a key feature, and there are many ways to do that, but I think infusing that into the system before you get to some of the structural reforms is really important to be able to sell that it's going to make a difference.
Lucas and then Joe.
I guess I was just going to reiterate what I said. I think there's like a real appetite and understanding now for the need for reform. And, abolish ICE gets a lot of attention, and I'm not going to get into that debate. But I think that we need equally catchy and broad campaigns for reforming the administrative process and humanitarianizing, if that's a word, making more humanitarian. But I know Greg and others are going to come up with better ways of saying this, and I don't know where Frank Sherry is, but we could use him too. To make the campaign has to include changing the substantive law and having a fair adjudication process, not just addressing what the enforcement regime, functionally looks like. And I think there's an opportunity to do that now because of the openness politically for addressing the problems that the Trump policies have so clearly exposed.
Joe?
Yeah, and I just wanted to add that I would encourage the policy folks in the room to dream big. I think, we have a tendency, because we've been on the defensive for so long, that to not take advantage of opportunities to define ourselves and our own goals. We're constantly thinking about, well, what do those others think of us and how do we respond? So if this is going to be a negotiation, dream big, think, outside the box. What would we really don't think, what do we think can happen? Start with, what do we want this to look like? What's everything that we want? And start from there. And the other quick thing is just to emphasize the need that we need to convince the public at large that this is a really important issue. We all know, and it's really, in a sense, we're sort of preaching to the choir, but you know, for somebody who doesn't pay attention to these issues, like, you know, you'll hear, why do I care about due process for someone who's not even a U.S. citizen? I think we need to come up with a really good response to that.
If I can add my 2 cents before I take the next question, you know, to me, it's somewhat similar to the current reform on criminal justice. We're seeing momentum there to make major changes there. And if we can achieve that, I think immigration reform, and particularly in the immigration court system, could be the next big thing. But turn it over to Jim Tom Haynes.
Good. Yeah, I am Jim Tom Haynes. I've been practicing immigration law, including removal law, here in D.C. since I knew Juan as a young law student at Interpreter Releases. And I must say that in the removal system, it sure feels like the deck is just stacked against the alien especially since 1997, when Congress really did a number on the immigration laws, taking away the discretion from the immigration judges and redefining crimes to where so many things are aggravated felony, including misdemeanor shoplifting. And maybe this is more in the way of a comment, but it seems to me that the way ICE is loading up the system in the immigration courts, including issuing NTAs to people who've already applied affirmatively for asylum, taking them from the asylum office at USCIS to the courts, and issuing instructions to the chief counsels to recalendar these, I don't know how many, 200,000 cases that have been admin closed. For decades, ICE, the chief counsel's office, have routinely agreed to terminate the case, or have the judge terminate the case for it to be sent back to USCIS for adjudication, where you have an approved visa petition and the person is eligible to adjust, and they no longer routinely do that. And it just seems to me that sometimes that they're trying to load up the system to where nobody gets through, because you already have a system that's jammed, and they're trying to put more into it. And I keep thinking, are they doing this on purpose so that fewer people actually get through the system and become voting citizens?
Right. Well, I'll add one to Jim Tom's list, which is the use of detention as a club, the aggressive use of detention for the coercive effect that it has on individuals who are detained, and forcing them to give up their claims and get out of the system by virtue of the very fact of detention that they can't tolerate, regardless of the strength or merits of the claims that they may eventually have, if they could withstand waiting for an adjudication for the period of time that it's going to take to get there. So we didn't talk that much about detention, but it's a key feature of what we're talking about.
Last question.
This is more of a comment than a question. My name is Betty Stevens. I'm chair of the Federal Bar Association's Immigration Law Section. We have been significantly involved in pushing actual legislation to be introduced, hopefully in the next session. We have people in both houses that are actively working on commenting on the bill that we have. There is an actual Article 1 bill drafted. You can see that at the fedbar.org website under government relations. There's a whole site devoted to Article 1. But I think the comment is that this is going to be a very political issue. We're trying to make this a bipartisan issue and get input from both sides, and that is why I will say the FBA bill is specifically not attempting to change jurisdiction. This was drafted during the previous administration when both houses were Republican, and there was not going to be any movement if we attempted to really work with jurisdictions. So please take a look at the bill. If you have comments on the bill, you can reach us through the FedBar website, and we would appreciate people talking up the bill. We've been working with the ABA. We are working hand in hand with the National Association of Immigration Judges, and if anybody else wants to comment on or help us push this bill forward, please contact your senators or representatives. Thanks.
Thank you. Well, with that, our time is in. I want to thank Juan for all that he did in trying to reform our immigration court system and judicial review. I want to thank the Center for Migration Studies for convening this conference and trying to push the ball forward, as well as my panelists. Let's hope that the conversation continues, and maybe if we reconvene in 5 years, we'll see some positive changes to all of this. Thanks, and we'll take a break.